Judiciary Committee this Tuesday morning, April 8th.
Afternoon.
Good afternoon. Welcome to the Judiciary Committee this afternoon, Tuesday afternoon, April 8th. We are continuing where we left off as far as a walkthrough of the amendment to S45. And this is what, version 1.2, is that?
Yep.
And over to you, Mike.
Hey, can I get chair?
Yes.
Draft 1.2.
Draft 1.2, yes. And we'll probably take up a next version tomorrow morning. And maybe kind of start at the beginning to kind of get us back familiarized, if that's all right, just to.
Sure. How much of my tabs? All right, so this is Mike O'Grady with Legislative Council. Last week, you started discussing the proposed amendment to draft to S45 and act relating to protection for nuisance use for agricultural activities. You left the findings alone in the definition of generally accepted agricultural practices. The definitions, you heard some requests for changes. You heard a request that the RAPs be referenced where applicable, where the requirements of the concentrated animal feeding operation are under an active permit. And then in the definition of nuisance, you had some discussion about whether that should be there, what it should include. I don't believe there was any actual request for change.
I think the one was adding particulate matter.
And then on page 5, in the threshold of showing good standing in order for the person to assert nuisance protection, you wanted that to be proven by a letter from the agencies. And then at the bottom of that page, in the substantive assertion of the protection where it says the nuisance protection for an agricultural activity shall not apply whenever a nuisance. You want that to also say whenever a nuisance has a substantial effect on health, which was based on the Arizona law, substantial adverse effect on public health and safety.
Yeah. So that language is.
So it would read something like the nuisance protection for an agricultural activity provided for under subsection A shall not apply whenever a nuisance violation results from the negligent operation of an agricultural activity or the agricultural activity results in a substantial adverse effect on the public health and safety.
Yeah. Barbara.
I think we probably did talk about this, but I'm trying to remember how substantial is looked at.
It's going to be a court determined standard. There is already in Vermont law, you can see on page 4, line 18 and 19, an ability to overcome the nuisance protection by showing a substantial adverse effect on health, safety, or welfare. So there should be some prior history precedent on that standard and its application. But it is also something that's going to be fact specific that a judge is going to determine based on the facts in front of her.
And just to back up, as far as the letter, that was going to be may be approved by the.
Yes.
Okay.
Yes. Moving on to page 6.
I think that's where we left.
That's where you stop. And this is in the section providing nuisance protection and or exceptions, you are stating here that the nuisance protection shall not affect the right of any person to recover for any injuries or damages sustained by the person due to an agricultural activity polluting waters of the state or groundwater or due to the agricultural activity causing the flooding of the person's land. Then there's a question, do you want that except when the flooding is caused by an act of God?
Is that the language that we use still, or?
Act of God?
Yeah,
You don't like it. I run into your objection to that language in the past. But it is used in some places, in statute still. But the question really is,
archaic language.
yes.
I mean, it's from another era.
But you also need to look at the concept of this is where a person's, where the right to farm nuisance protection is not going to apply. And really, is flooding from an act of God something that someone is going to bring suit about? So that's really, is flooding of the person's land sufficient? So I put it in brackets because I don't necessarily know if it's necessary, but it is language that's used in other states.
Yeah, I mean, you were also talking last week about other language as far as reasonableness or something like that to get at the same kind of issue that it's caused by an out of the usual 100-year storm or whatever. I mean, I thought that there was something that could be a little more specific.
So you're saying nuisance protection does not apply or would apply?
I'm saying the nuisance, yeah, yeah, the idea is that the protection, well, let me think, it's not really. Yeah, I don't know if that it's so much that the nuisance protection.
Or do you leave this section out?
No, I don't think we leave the section out. I think it's important to have the section in.
Okay.
It's just a matter of trying to capture flooding. Yeah, I think keeping out the except when the flooding is caused by an act of God, but if there's another way to get at the point that.
Well, the standards are, as you noted, they reference the threshold based on the severity of the storm, and they do that by year, like
Right.
25-year storm, the 50-year storm, the 100-year storm. Now, the storm that farms received some water quality relief from under the federal law is the 25-year, 24-hour storm.
Right, that's kind of what I thought we were going to try to capture.
And I can build that in.
Is there a definition in any place of act of God? Some people are, I may be way off, but I think some people are fearful that it has something to do with religion, and I don't look at it that at all.
No,
They just want to get rid of it.
There are
not religious or faith-based or anything.
you know,
There is some kind of meaning to it.
it generally, when it is defined, it's defined as something that natural disaster or similar event that's beyond control.
Back to building art.
right, and I'm trying to get at something even more specific than that. I mean, act of God is pretty general, and natural disaster is pretty general. But if there's already out there somewhere that 25-year flood,
Right.
That's what I'm because that becomes a little more knowable, I guess. Although,
But, all right, so you're saying that the person receives nuisance protection during the 25-year, 24-hour flood.
right, yeah.
And the
I
most of
think that
the,
was where we were getting some testimony from some farmers that there was a concern that any kind of flooding would.
so most of this language really is not applicable.
How's that?
Because it says the protection does not apply for injuries caused to polluting waters or groundwater due to agricultural activity. You're saying that the farmer shall not be subject to a nuisance claim from an agricultural activity when the alleged harm is caused by a 25-year, 24-hour rain event.
That's what I'm suggesting, but maybe it's not worth its thinking, and I can get some other testimony on that as well.
No, I can do that. I can just, this language isn't that.
All right, well, let's think about that.
Okay. I'll give you an alternative.
Michael, so if you put the 25-year thing in there, it's 50-year storm.
50-year storm is still qualifying.
Okay, that's what I thought, but I wanted to hear it.
Who would be the judge of that?
Yeah. And there's some language I can throw in from water law as well.
Yeah, yeah.
Is there any protection for farmers for other types of claims like trespass when you have acts of God that they can claim?
The only one I can think of is a release of a hazardous material. When the hazardous material release is due to some natural event.
They can claim there's something. I just want to make sure that that there isn't already a protection out there. We don't need to try to bake it in here.
Right. Well, let's think about that one a little bit further.
Okay.
You can provide an alternative.
And then the chapter,
Before you go, I'm sorry, Ann, go ahead.
Well, I was confused. Steve was here too, but we heard some testimony that this language might be confusing. Confused by that. Wondered if you had any thoughts. Is that what you were getting at when you said, well, then maybe you don't need this?
well, I don't know if this language meets the intent.
Okay,
And this language is used in other states. It's normally something where you're conducting your agricultural activity on your land. It's a lawful activity, but you somehow pollute your neighbor's land. You don't get right to farm protection for that. You're still subject to an action for that. And the person that's harmed can still recover injuries for that.
that's current law. That's or as,
This is what this language would do.
okay,
But the
Right, so
chair's request would provide the nuisance protection when there is flooding from a 25-year plus storm. And that's not what the language does.
maybe you can explain to me that, because I think I was bumping up against what she said before, that this doesn't seem to really comport with the intent of the bill.
It doesn't comport with the chair's request at all.
But we're gonna change that.
Well, so let me, I guess, try to simplify this. I mean, what I was trying to get at is, the exception for the fact that you don't have the nuisance protection. And I want to say you don't have the nuisance protection from pollution or for flooding, unless that flooding is an act of God, which I'm defining as 25 years.
Okay,
plus.
all right.
That's how I'm kind of looking at it, is it's like, if it's just your flooding from normal rainfalls that we get all the time, you're not protected. But if it's like a significant storm that a farmer doesn't have any control over, then the protections apply. Did that finally make sense?
They probably wouldn't have any control over any of the storms.
That's true.
Well, but if there's a water quality standard that says they have to have protection up to a 25-year plus.
No, I know what you're
Yeah.
saying there, but Yeah, they got no control over any storms and any water runoff.
They are supposed to have control over water runoff.
That's the thing. That's where I was getting a 25+ year.
From their production facility.
And that's in which law? Where's that in again? Is that the federal?
It's kind of changing right now. It's under 6 VSA chapter 215, but it's also under the Federal Clean Water Act, CAFO, rules.
Okay.
That makes sense now?
Yeah, it helps me understand that you're trying to get at something exceptional,
Right.
make an exception for the exceptional event.
Well, exactly.
Okay, I think I get it.
Okay.
Thank you.
All right, I'm gonna move on.
Yes, please.
Page 6, line 7 and 8, the chapter does not restrict the ability authority of the state to protect public health, safety, environment, or welfare. So state still has its ability to use whatever authority it has for public health, safety, environment, and welfare. Then you get to the liberal construction severability. This is an existing statute, but subsections A and B are being added to direct courts to liberally construe this law in order to effectuate the purposes of the law. And it shall not lose the nuisance protection due to a change in ownership, a change in crops, change of farming method or conversion of farming practices or agricultural activities. One of the things that has been in discussion on page 6, line 15, I think some in the agricultural community would want that 5 years to be 10 years. But that has not been changed yet by anyone.
Is that something that we could do?
Yeah, so just to look forward to what we're doing, the question is whether that's to be us or the agriculture committee. So we're going to send this over to them.
Over to them.
Yeah, because they need to really weigh in on some of the definitions, like generally accepted agriculture practice, which is really out of our realm of knowledge of jurisdiction. So this is one of the questions that may make more sense for them to look at than us.
Is trespass something that they're going to be taking up too much?
I assume they're taking up everything that we've changed
Okay.
versus the.
So things could be reversed potentially on the other side.
Could be.
Okay.
Yeah, go ahead.
Yeah, I would argue, that us discussing 25, 50, and 100-year storms is beyond what we do. And it should also be back in the
Yeah,
ag committee.
that's also a good point. Yeah.
But going back to say 25-year storm, and is there a definition for that, or it's just a determination after the fact?
There is a definition, but it's not the most, there is a definition.
Okay, just for sake of what I want to say, let's say a 25-year storm is 10 inches of rain, okay? And over the course of 4 days, there's 2 3s and a 4, which equals 10 inches. And the runoff is, because the ground is saturated, is going to be about the same as a 25-year storm, but it's not going to be designated as a 25-year storm. And the people downstream are going to be able to sue because of the runoff. Yes or no? I guess that's my question.
It's the 25-year, 24-hour rain event. So it does take into account the duration of the rainfall.
24 hours, but not over the course of a couple of days.
Not over the course of a couple of days, but I'll have to get you that standard. It's not.
Because with the way our weather patterns are now, we would be more apt to get 2 3s and a 4, over a couple of days than the big storm.
But remember
And the big storms are more common also, but so aren't all those medium-sized storms, which could be really detrimental to the farmers.
but generally the farm is supposed to control the runoff that comes off of its production facility, right? And both under state and federal law. Federal law is the one that provides the 25-year, 24-hour exception.
Right, no, I understand that, but you can only build your systems so big to handle, say, if it's built
Right,
into that 25-year storm.
And this is saying that if you built it to that and there's flooding that exceeds that, then you're not subject to nuisance. You're not going to be sued for the things that escape your property or create impact on the significant use and enjoyment of your neighbors.
As long as it happens within 24 hours.
Well, as long as it meets the standard, yes.
And I'm going back to, what's on my mind is, North Carolina and Lee, I mean, they got, what was it, 15 or 20 inches of rain from Helene. But one thing that people don't think about, the 2 days before, they got 10 inches of rain, which kind of flew under the radar and saturated everything and made things worse, which could happen on a farm.
I recognize that, but I don't know how to address that.
Well, you're supposed to, Mike. No, I'm just kidding. No, it's, and I wasn't looking for an answer to it, but it was just a situation that could happen. That's, by our definition, no longer an act of God, and the farmers are going to be responsible for acts of God. So I think there needs to be consideration in there for that, but I think that's above our pay grade. I think that's a job for ag.
Sure.
I'm just gonna add, I feel like there should be some threshold that we're saying that the protection goes for. Maybe it isn't this 25-year and 24-hour. I will say for me, act of God, knowing that there isn't necessarily a clear definition of it, creates. So I feel like we need a definition of what this threshold is.
So for this next version, if you could have an actual threshold, the 25-year thing, or keep the act of God part in there, and we'll
I'll give you some alternatives.
let ag
Okay.
take the first final crack at it. Yeah, Tom.
Not anything above accepted practices can handle. I mean, you can't foresee something this subjective.
Right, and just to make clear, this language that we have in there is like any flooding, you don't have nuisance protection. I'm trying to figure out an appropriate additional protection for the farmer, just to not lose that fact that I'm trying to figure out a way to, if it's just like natural runoff that they should be controlling, they shouldn't have the protection. If it's to God, if it's not natural, if it's whatever, then they, they should have the protection. So, but yes, if we can get some alternatives, and perhaps it's a matter of having some alternatives that we're going to punt to let people who know this a little bit better.
Okay.
But we may as well throw some alternatives out there since we've been talking about it.
Okay.
In the past, has ag dealt with these types of issues?
Yes, it's come to both of your committees in the past. And the last time it was really substantially changed. The last couple of times it's been substantially changed, you both addressed it.
Over 15 years ago.
2004 was the,
Was it? Okay, before.
and then 2020. So those both times. Yeah, you changed the definition of agricultural activity that receives protection.
I don't remember us.
No, that's 2004.
No, like 2020.
Oh.
Next time.
Was it here in 2020?
It was.
Yeah, it was definitely in Senate Judiciary.
Oh, but it could have anyway. Any event. So section 5754.
So this is a directive that courts liberally construe the subchapter, chapter in order to provide the protection as outlined in the purposes of the statute. And then you have this provision that the ag activity doesn't lose its nuisance protection due to change of ownership, change of crops, change of farming method, or conversion of farming practices. If any provision of the chapter is held invalid, there's a severability clause. You don't necessarily need that, but that's existing statute. And then you get to the required mediation prior to suit. So a person shall not bring a court action arising or based on a claim of nuisance arising from an agricultural activity unless the person and the operator at least once attempt to resolve. You had asked that there be language about cost, page 7, line 12 and 13. It says that the party shall share the cost of the mediator equally or according to agreement between the parties. You heard from the Agency of Ag that USDA will provide mediation free of cost. So that would be according to an agreement between. Then you asked, Will, it wasn't really you, it was a question from Senate Judiciary that was never addressed. But what is the timing, the time frame for mediation to be conducted? And when is the requirement met? And I didn't have an answer for that.
I'm not sure I find that a big problem either.
I think, right, if you, and then you need to show a statement that you attempted, and that's the threshold.
I don't think people should be held hostage.
Okay, so I'm not going to address it then. Then last effective date. Generally, acts apply prospectively. They don't affect current suit. They don't affect judgment. But I believe your committee heard that there were concerns that this act would be construed to apply retroactively. And consequently, you wanted a strong statement that it did not. And so the act shall apply prospectively, shall not affect the suit begun or pending at the time of passage, shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred prior to July 1, 2025, and shall not serve as the basis under Rule 60B for relief from a judgment issued prior to July 1, 2025. Rule 60B is a change in circumstances. Court, it's usually in very narrow circumstances, but then there's a bit of a catch-all, can allow for a change in a judgment. And you would not allow that for any judgment that occurred before July 1, 2025.
And so this is accounting for the Forestville situation?
It would apply. It would not, this would not allow the application of this law to their prior judgment.
Would it impact any other cases that we're aware of?
I don't know of any that are ongoing,
So
but
this is in response to a single case?
well, this was in response to a request I received from the chair.
Okay. Am I thinking about that the right way, Martin?
Yeah, well,
It's in response to a single case?
so generally speaking, we don't need this language generally, but we heard from one of the witnesses who was concerned that despite our general language that things do not apply to ongoing lawsuits, that there was this concern, and we just wanted to spell out very clearly in this law, not just rely on our general.
The question I have on that is, it seems like we're taking into consideration that the plaintiff of a singular case, and this is punitively impacting the defendant.
No, I don't think it's punitive. I mean, it's making it clear.
But it is benefiting one of the two parties.
No,
Because she was concerned about a 60B motion coming, because they've been known to file those.
right.
So this specifically precludes them from filing that on a specific case.
Doesn't preclude them from filing, it would preclude the court from applying this law to their judgment.
Right.
Yeah, they could still file.
But you would say this is atypical that you've seen in legislation?
We generally don't include
Language like this.
this.
Okay.
So is the problem, there's three different phrases in here. So the serve as the basis under Rule 60B.
I mean, you could just limit it to the Rule 60B language.
No, I would be, but that's different than our general
Generally, you don't have to do anything because in one DSA 211, 212, 213, and 214, it says that laws applied prospectively don't affect judgments or orders, liabilities incurred prior to the effective date of the law. The only kind of exception to that would be a Rule 60B motion, which there are 4 or 5 criteria that you can qualify for it. The first 3 or 4 are inapplicable to this issue. And the 5th is kind of a general catch-all, which usually has to be filed for within a certain amount of time. I can't remember the amount of time. I don't have a concern about 60B applying.
You don't think this is necessary?
I don't. I definitely the first 2 clauses, maybe even 3 clauses, are not necessary. Because you're not unless you say a law applies retroactively, it does not, and you're not saying that this applies retroactively, so it doesn't apply retroactively unless you try to undo a judgment of the courts. It's not going to, legislation will not undo it. And you've tried to undo them in the past, and the courts have said, thank you, but no thank you. And it shouldn't affect any prior liability otherwise. But you do have a slight window under 60B. I don't think it's going to apply. I don't think a court will allow it to apply considering the duration since the judgment. But if I were the plaintiff's attorney, I would be concerned about that.
But that would be the case in any kind of.
In any
case.
In any.
Right, okay, so I get the point of what Zach is saying on that as well, because then it does seem more specific to this. Ken, did you want to weigh in on that as well?
Well, I'm just gonna hold off from it.
So if it's really not needed, then we should just take that out, take out beef. I guess my question though, well, there is one further question though I would have, is that if it's an ongoing trespass, if it's an ongoing nuisance, how does that figure in here? If it's, you have an injunction saying you need to do things to stop the nuisance.
60B is a relief from judgment, right? It's a relief from the judgment that's already been issued.
Right.
And so if it's ongoing, then the judgment, the order hasn't been met, and that's another issue. And so
there's an order against a particular activity, and subsequently there's a law that passes that makes that activity fine. That doesn't relieve the person of having to comply with the order related to that activity.
that's my understanding, yes. That's what I would argue.
Yeah.
Okay. All right. So that is that.
And one other thing, I don't know if you caught on page 7, line 17, 18, there was an extra or trespass that was in there that needed to be struck.
Yeah, but I already have that noted.
So we have a few changes that we'll look at then tomorrow at 10:30. Before we ask for some advice and counsel from Committee on Agriculture.
Okay. So
Can I ask one more question?
Yeah.
On page 3, line 15, good standing. Is this also, I mean, the theme of today is, I guess, typical language, but is this typical language that we usually include, good standing in the state?
So it is used in a couple of different agricultural programs. It's included in ag water quality financing. It's included in grant language. It's honestly, I think it's in Administrative Bulletin 3.5 for when you get a grant. So it's not new language.
But outside of legislation, outside of grants or the applicable Like if they're seeking benefit from the state, not,
Um, so it,
not with litigation, I guess is my question.
well, you're looking for a threshold to, you don't want a farmer to be able to be violating the law while they're conducting an agricultural activity and then assert right to farm protection for that agricultural activity.
Right. No, I get that.
So if they're in good standing and they don't have an order against them, and frankly, a final order is pretty far down the line, an active enforcement violation that has reached a final order, that's pretty far into the process and they're continuing to violate. You don't want to give them the right to farm protection.
Can they get relief from those orders
Oh, yeah, they're given opportunity, yes.
to relinquish it? Okay.
Mr. Through you, Chair, can you just share the path that you see ag taking this? Or is we going to give them the bill? or
Yeah,
they-
no, I'm gonna send, yeah, it's gonna be sent to them. They'll have jurisdiction so they can make changes particularly to, I mean, the areas that are within, well, lots of this is within the jurisdiction jointly with us. But specifically, we've had questions about the generally accepted agriculture practices, and that's really a basic standard. Yeah, that is kind of out of our bailiwick, but they will be open to look at, you know, the other parts of the bill as well.
So just to clarify, we'll vote it out. And
I
then we'll,
don't think we're gonna vote it out until we hear back from them.
that's what I wanted to confirm.
We'll either get jurisdiction back to us if there's gonna be further changes, and we can decide at that point if we want it back. Because there's time, or we'll take a straw poll and whatever they end up with. So we'll figure that out when we see what they do with it.
Would you request on the floor to send it to Ag?
Yeah, probably tomorrow afternoon after we take one look at these final changes that we have. Let's see if we can get them started on it. Okay, anything else on 45, I think at this point?
Not right now.
All right, so we're gonna move on to. So we have a couple bills that are being considered in House Environment. I guess they have tabs for these bills. And there's some parts of them that they want us to take a look at and we can decide. We can decide in this situation if a drive-by is sufficient, or if we are going to want to actually take possession of this. But we'll start by having a walkthrough, and I do have testimony on set up for H86, which I think has more to do with this committee than H230. But over to you explaining H230.
Do you want an overview of the entire bill, or do you just want me to focus on those sections that were?
Level overview, so we kind of know in context of what.
Okay. So this is an act relating to the management of fish and wildlife. It has multiple provisions related to the Department of Fish and Wildlife's authority. It allows the Commissioner of Fish and Wildlife to designate Labor Day as a free mentored fishing weekend. It allows or changes the fee structure for fishing tournaments. It changes the penalty amounts for big game violations. And I'm going to come back what a big game violation is for you because it will affect your jurisdiction. It changes the jurisdiction of fish and wildlife violations. Sections 4 and Section 5 are the big sections related to this committee's jurisdiction. It allows the department to adopt rules related to the protection, conservation, and taking of reptiles and amphibians. It allows or it clarifies the existing authority about the transport, import, possession, and stock of wild animals. It provides some exceptions for permitting of import of wild animals. It amends the incidental taking law for threatened and endangered species to maintain that the location of certain species and permits issued for those species are going to be confidential. And then last, it repeals the requirement that the Department of Fish and Wildlife compensate a farmer for crop losses caused by bear or deer. So
Raccoons.
no, doesn't apply to raccoons. It applies to this deer or bear. That's it.
What's the definition of deer? What's included in that?
No, it is not. So you do not get it for moose. It's for deer or bear.
Just with raccoon and Barbara mentioned the moose, I'm just thinking that that can do an awful lot of damage to crops.
So it's generally not asserted, and it's usually only asserted by one or two farmers. And so the department is has been resistant for a long time in the concept and is looking to have it removed. So not the first time they requested it or discussed it.
Now, I'm not looking to change it, I'm just.
So really, sections 4 and 5 are jurisdiction, and to an extent 3, or definition 3. So currently, right now, you might not know this, but almost all fish and wildlife violations are crimes or criminal violations that are addressed in the criminal division of the Superior Court. There are 7 violations that are defined as minor violations and are subsequently addressed as civil violations in the Judicial Bureau. Because of the burden on the court system, because of the severity of certain crimes, because of just the pressures on the judiciary as a whole, including the Attorney General's office and state's attorneys, not all fish and wildlife violations are contemporaneously addressed or in a timely manner addressed, and or may never be addressed. And the department is looking for ways to allow for violations to go forward while also for removing a criminal violation for activity that many people don't realize is a criminal violation. And they are proposing on page 4, line 13, where it says the Vermont Criminal Division shall have exclusive jurisdiction over fish and wildlife violations, say with the exception of the violations related to section 4572 and chapters 1, 2, 3, and 1, 2, 4. I'll just
Like, has judiciary weighed in on that, or anybody on the number of cases this could put into the system?
So in House Environment, they asked the Judge Zone to come in and look at this language. He made some suggestions, but generally I wasn't there for his testimony, so I'm just characterizing what I was told. He supported the change and thought it would be helpful.
But no comments on I'm just thinking of the backlog and added cases and.
I wasn't there for his testimony, so I don't know if he addressed how it would affect backlog.
Can I clarify? Because maybe I heard this wrong. Because right now in current law, all of these are criminal.
Except for 7.
Except for 7. And this is further limiting it if we do this.
No, this is opening it up.
Opening up, okay, so.
It's opening up. You will see in section 5, and what is the definition of a minor fish and wildlife violation? It's going to include, except for big game offenses and under revocation offenses, any fish and wildlife violation defined by 10 VSA 4551 and not otherwise listed in this section shall be charged as a minor violation. So everything except a big game violation or you're operating under suspension. And a big game violation, you can see that that definition in section 3, that's when you're taking, possessing, transporting, buying, or selling big game, so deer, moose, bear, turkey, anadromous salmon. When you are violating the threatened and endangered species law, when you are violating or taking game during a license suspension, when you are engaged in the sale of covered animal parts, which are usually protected wildlife parts, or you're interfering with hunting, fishing, or trapping, or you're engaged in illegal commercial importation or possession of wild animals. That's a big game violation. So that is always going to be criminal. But everything else will be civil unless the offender has a prior history of fish and wildlife violations. There is no need to seize evidence in order to further investigate the violation. There's no need for criminal warrant to further investigate the violation, and there's no possibility of forfeiture.
Yeah, I guess, I'm sorry, Karen.
Oh, yeah.
I guess I'd like to hear from somebody to find out how many cases this is gonna be and if it's gonna add to the backlog.
Yeah, I've reached out to, I've had Dave reach out to them.
Oh, okay.
So,
It's going to add to the backlog where?
In the court system.
Right, so these are already violations that are in the court system, and they're already in the criminal division, and they're already part of that backlog.
Oh.
And what this does is it takes those that do not otherwise qualify, takes them out of the criminal division and puts them in a judicial bureau.
Oh, okay.
yes, the voting
Okay.
basis from the.
So that was what I was saying.
Yeah,
Okay.
yeah. Okay.
So more of these are going to be intuitively ticketing offenses, right? Civil ticketing offenses.
Are these the same ones that appear in the schedule of fines now?
Do you mean which schedule?
Civil. The,
No, so the civil ones are the 7 that you see. The beginning on page 4, going on to page 5. Those are the minor fish and wildlife violations. And you're adding to them everything else except big game, suspension, violations, or any where the warden has determined, or the law enforcement officer has determined there's prior history, there's a need to seize evidence, there's no need for a criminal warrant, there's no possibility of forfeiture. So, for example, from prior history of my own, if you fail to control your tip-ups while ice fishing and you get violated, that's a criminal violation. And so that,
What do you mean by that?
it's a citation.
yeah, if you are not in proximity of your tip-ups while ice fishing, that's a violation and it's a criminal citation.
Misdemeanor.
something?
Yeah, you have to be able to control your tip-ups. So,
Within 50 yards or something? I mean, what?
no, you have to be in proximity to your tip-ups to control them.
I think it's within sight, is pretty much what I hear.
But in any event, that's no longer, and if I didn't have a history, if I didn't have, there was no need to seize, there was no need for forfeiture, no need for a warrant, that would be charged as a civil and not as a criminal.
So will you expunge your ceiling?
I paid the ticket.
Dismissed.
Ian,
Wow.
Could you just explain what forfeiture means and specifically the seizing of evidence? So like, yeah, just those two B and D.
Yeah, so underneath Fish and Wildlife law, implements used in violation of the law may be seized. That includes rifle, that includes any other weapon, ammunition. They can be seized for purposes of determining the violation and issuing the citation. There is further authority to keep that property and not return it to the violator and to put it through a forfeiture hearing. And so I have to refresh my memory on every time forfeiture is authorized. But it's there.
You don't regulate.
So the department does seize. It does return equipment to the violator, but it will also retain it and put it through forfeiture hearings.
So for B, because I don't understand this area at all, is that the necessity to seize evidence based on the severity of the violation, or is it based on the conduct of the defendant, or
I think it could.
what type of violation it is?
I mean, I think it could be either.
Okay.
For example, if you were going to try to prove that there was a violation of the transport requirement or transport offense of illegal commercial importation or possession of wild animals, you may need to seize evidence in order to prove that.
And so this would say, okay, in that instance, because evidence was necessary to be seized to be able to prove it, we can't have this.
You're not going to be charged as a civil, you're
It's
going to
gonna
be charged as a criminal.
Yeah. Okay. That's very helpful.
Okay.
And this is where I'm not certain if it's in our jurisdiction or if it would be for environment. But when it says, this is line 15, the offender has no prior history of fish and wildlife violations. I'm assuming that's any violation. Was there consideration of if it was no major violation, or I don't know what the different minor but I feel like if somebody gets a minor violation and another maybe it still shouldn't be a crime.
So the minor ones are the 7 that precede subdivision 8 on page 5 and going back. Those are the only minor. All the rest are just fish and wildlife violations. And the House Committee on Environment asked the department to provide a list of all of them. And it's not a huge volume of any, but it's a pretty long list. And those are all fish and wildlife violations.
So it's if you have any of those before, no set period of time or anything, but if you've just ever had one, you would not be eligible to get this as a civil offense.
That is my understanding of what the department is proposing.
I just feel like there could be some room there, but I don't know if that's us to decide or it's to the department.
Probably them, but I think, so just to clarify though, the 4572, which says minor fish and wildlife violation, those are not included in 8A that says fish and wildlife violations.
That is correct.
Okay.
I feel like that's not clear. That is, and maybe it's just not clear to me.
Well, if
It says it's not otherwise listed in this section.
Okay.
right, okay. Right. So presumably, if somebody has one of those misdemeanors, they have sought expungement because those are, I'm pretty sure that fish and wildlife violations are misdemeanors. The misdemeanors at least are eligible for expungement.
I don't know that.
It's always best to try to not know expungement if you're legislative counsel, because you never know if it will be foisted on you. So, but I believe that is the case. They're misdemeanors that are expungible. They're not accepted.
I mean, I just wanted, like, it seems like there could be room there to adjust it. I can go either way, but it's understanding the goal of this. If the goal of this is to have these offenses be seen and be held accountable in a more timely manner, seems like having more go to the civil option could be helpful.
So you would want what to change?
The offender has no prior history of, this is where I don't know. of major violations, or it's within the past 5 years. I don't know, I'm just making up numbers.
I mean, let's just double check that they're expungable. And almost certainly are. And if they're expungable, that takes care, I think, of that concern. Or and soon sealable if SBAG makes it through.
Let's say that.
So,
So that's the two sections in 230 that apply to your jurisdiction.
So I'll note also this, I mean, I think it's great. And I know that, Tom, if you might recall when we started doing the criminal, the restatement of all the criminal laws, one of the things we started talking about was decriminalizing certain misdemeanor offenses. And we even had some testimony related to some of these fish and wildlife violations. And the issue that we had pushed back and we never advanced it was the concern about needing to have a warrant to seize property and such. And this is a nice elegant way of dealing with that.
Yeah.
That we didn't think of back then.
Yeah, not monitoring a step up shouldn't be criminal.
That's right. And there's a whole long list of them that shouldn't be criminal. So I think this is great. Go ahead.
So are we done with our part? 'Cause I have a question that's not in section 6, which isn't us.
Just, yeah, he's here. Why not?
What are specified reptiles and amphibians? Page 6, line 10, number 3, prohibit the taking and collection of specified reptiles and amphibians. Is there poaching that's going on as far as that type of thing goes, or?
No, what
I'm
this,
just curious.
what this would do would give the commissioner, not the board, the commissioner, the authority to establish rules or prohibitions for the taking of certain reptiles and amphibians.
They have the rattlesnakes down in the Castleton area.
Those are all threatened and are already threatened and endangered, so
Right.
they're already protected.
No, but I'm saying if they
Well,
came
what-
back with a vengeance, then they would also be able to make rules for control. I'm assuming.
Yes, and this is for, so people aren't taking native turtles out of ponds and collecting them and selling them, or mud puppies or reptiles and amphibians like that, where there's either looking to use them as game or looking to use them for commerce.
Okay.
And so the commissioner would have the ability to set standards, set prohibitions, seasons, catch limits, etc.
Great. Thank you.
All right. Is that all on 230? Because I have Judge Zones in the Zoom room and I can have him weigh in on this since he was available. Is he been admitted? Is he there? So if you could end the sharing of that screen, and then we'll go to Judge Zone in a moment. So Judge Zone, are you there? And if you can weigh in on H 230 sections 4 and 5, we'd much appreciate it.
Well, good afternoon. Can you hear me there?
Yes, thank you.
I'm in my office. I thought it was quicker than running over.
Yes, that's the great thing about the Zoom room.
For the record, Tom Zone, Chief Superior Judge. I am looking at draft 1.1, H230 from 4/7 at 9:04 a.m. Is that the draft?
Correct. That's correct.
All right. It looks like section 4 would be the section where it would start tying into the judiciary. And it looks like on page 4 that's the change at 4572 seems to work. I did testify before the Environment Committee on this bill, and I made some comments on what's now page 5, beginning on lines 12 through 20 about the authority of the issuing officer to turn something into a minor violation. And looking at, it looks like they have made some changes where it says the offender has no prior history. That's a very objective determination. they either do or they don't. There's no need to seize evidence is the second one. And the third subsection C on line 18 says there's no need for a criminal warrant. The word need is subjective, and someone could say that, well, they need a warrant. And a judge, I could look at cases, and I have, where I don't think they need a warrant, but the fact that they want to get extra evidence, that's the right of the law enforcement or the state's attorney to seek that. So I think the word need might not be an appropriate word for there. I would also note that the word need seemingly is looking forward, but at the time the warden issues the ticket, he or she would already know if they have utilized a warrant to further the investigation or utilized a warrant to seize evidence. And so you may want to consider saying that there was no warrant utilized in order to seize evidence in order to further investigate the violation, or there was no criminal warrant used to further investigate the violation. Those are direct subjective points for which there's no dispute. Either it was or it wasn't utilized at the time the officer writes the violation. And then subsection D, there's no possibility of forfeiture. That's objective. That's very clean, and it removes any subjective determination. But I just think that subsections B and C about a need, I think that could be worded differently to make it very clear that you either used a warrant or you didn't. And if you didn't, then you qualify for a minor violation.
But would it also be prospective as far as there might be a developing need for a warrant? I mean, is that what it's trying to get at as well, or?
Well, but the way the statute is written, the officer has already, at the time they make this determination, they are sending it. They're taking the affirmative step to write that violation and send it to the Judicial Bureau. So if something comes up later, they could dismiss or take further action at that time and say, well, it's no longer qualifies.
You know what to do with that, Mike? Is that?
I think I do. I think that input was pretty clear.
Okay. So it's not that there's, let me just throw another idea that probably, I've been making all sorts of things as clear as mud today. But should it, I mean, if it said there's no further investigation requiring seizure of evidence, or there's no further investigation requiring a criminal warrant, or is that kind of different than what you're getting at, Judge Zonai?
That's somewhat different. I think that the point, if the idea is that in cases where law enforcement has to seek a criminal warrant or a search warrant, that the matter should not be charged as a minor violation, that's a policy decision. And it should just, at this point, the officer, when they write the ticket, is the one, at that moment, they're charging them. And so it should be, what's the status at that time that it goes to the Judicial Bureau? And if they have not used a warrant, then it would seem to qualify.
Right. But I'm a little confused because I thought that that it had to be a criminal offense for you to be able to seize. You can't, on a civil ticket, seize evidence or have a criminal warrant, right? So.
Well, remember that's exactly what this statute is talking about. You start with all of these actions, all of these offenses are criminal offenses. And if in connection with that offense, you seek a warrant, what this statute says is the warden does not have the authority to exercise discretion and send that as a minor violation. It stays a crime.
Right.
But if it is a crime and the warden does not need to utilize a warrant and the other criteria match, then the warden is required to send it as a minor violation.
As long as Mr. O'Grady understands what we need to adjust.
It's going to be written in passive voice because it's just how it's gonna have to be written, but I think I can do it.
Ian,
Hey, Judge, is there anything else that a law enforcement officer can do in an investigation because it's a criminal offense and not a minor violation that we may want to include in these subsections so that if it were to move into being a minor offense, the law enforcement officer couldn't have utilized some tool they only could have used if it was a criminal offense? Does my question make sense?
It does. I don't know that I can really answer that. I haven't, I think that in some ways gets into giving advice to law enforcement on how to do their job. But but full disclosure, nothing jumps out at me anyway.
okay. Any other questions for Judge Zoning? All right, thank you very much, Judge.
My pleasure.
So maybe if we can take a look at that language tomorrow for 10:30, since we have you booked in at 10:30. So we'll take a 10-minute break and then turn to